What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Wednesday. Yeah, that's about all I got. Happy Wednesday. I've got some court. You guys want to watch some court? I want to watch some court. Let's watch some court. I've got a few clips from Judge Dad, aka Judge McNally, and Judge Simpson. That's what we have tonight. That's it. All right. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go. Nope. Lisa slid right in there in the intro for 3 months. Lisa, thank you so much. I do appreciate it. Congratulations on your 3 months, and thank you so much. I do appreciate it. You are awesome. Okay, now let's go.
W838685A and B. Is Alicia Craig here? Did you talk to your lawyer?
Yes.
Who's your lawyer?
Hi. Can I tell you that?
Mr. Carmen.
Mr. Carmen.
Can you get him in if you would? Come on up to the podium, ma'am.
I was actually out there looking for him. I forgot to tell him something, but I guess I'll leave.
All right, I gotta change this so we can see the defendant. Hold on.
Oh, there. Yep.
There we go. I don't want to block the defendant. Lizette for 20 months. Thank you so much, Lizette. That is awesome. Thank you so much. 20 months. Thank you.
Yes. Thank you. He's on the way.
There is the original charge. I'm gonna take this back to you. I need some clarification on this one. Mr. Carmen, your appearance. Let me call the case again. Alicia Marie Craig, 25W838685A.
And now Jedi's dropping 20 months. Thank you so much, Jedi. 20 months. Thank you. Jedi. And Rich at 19. Who else has a membership milestone they want to drop? You guys are awesome. Thank you so much. Rich, Jedi, Lisa, Lizette, you guys are all awesome. Thank you so much. And Mayor's here too. Mayor's here. The crowd's here. Everyone's here. Okay, let's go. I just rewound it. I just hit the rewind button instead of the play button. We got because I asked Alex for 4 months. Thank you so much, Alex. I do appreciate it. And Darth J for 3 months. You guys are awesome. Thank you everyone for your milestones. You guys are all awesome. I did just accidentally rewind it 1 minute, so we're gonna have to go through this again. Sorry.
Why?
Yes. Thank you. He's on the way.
There is the original charge.
Listen, I appreciate you.
I'm gonna
I
take this
appreciate
back
you.
to
I appreciate you more
I
than
need
you
some,
I can put into words.
clarification on this one.
You drop comments on almost every video, Lizette.
Mr. Carmen,
and
your
in almost
appearance.
every live.
I'm
Thank
going
you
to
so
call the
much,
case
Lizette.
again. Alicia Marie Craig, 25W838685A and B. Your appearance.
McNally, Condon, 73824 on behalf of the defendant.
Ma'am, your name?
Alicia Craig.
All right, so today is the date scheduled for arraignment on an operating with the presence of drugs and drive while suspended, revoked, denied. For purposes of arraignment, how does she wish to proceed?
Your Honor, she'll stand here and wait the formal reading.
Okay, I'm entering a not guilty plea, ma'am. I'm going to give you a $1,000 personal bond. She does not have any prior, oh yes, she does have a prior in 2020, right?
I believe that was out of state, yes.
Yes, I'll have.
I mean, it still counts. I just want you to know that,
I know it does.
okay? All right. $1,000 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no illegal drugs. You're not to purchase, possess, or consume any one of those. No contact with prosecution witnesses. Attend NA at least twice a week in person. We're going to give you a form. You have to go in person every time you go. You have to have the form signed every time you come to court. You have to bring the form with you. So again, no alcohol, marijuana, or illegal drugs. NA twice a week. No contact with prosecution witnesses. We're going to give you a new date. It's going to be what, October 1 again, Lisa?
9:30.
At 9:30, okay?
Your Honor, my client is prescribed marijuana for chronic pain and anxiety. She uses it 3 times a day. She's been prescribed since 2017. Can she use that while on bond?
Is that a medical marijuana card she
It
has?
is, but I believe hers is expired.
Well, I can't. It's,
The only reason I did not renew it is because it became
hang on.
legal.
I can't give you permission to use marijuana when you don't.
Mayor, did I miss your stream? I may have missed your stream, Mayor. I am so sorry. If you're headed back home, I know you sent me some links the other day. Yeah, I apologize. I'm not a good friend, Mayor. Right now, I am not a good friend, and yeah, I am so sorry. If you're in New Hampshire, I can stop by and visit, and I can like crash on your couch on my way home this time. You want to do that? I can stream from your place instead of the other way around. We can have some fun. Let me know.
Have a medical marijuana card. I can't do that. I mean, that's like me, the judge saying it's all right to do. No, I just can't. I'm sorry.
If she gets it renewed and valid, can't she?
Well, if she gets it renewed and you guys bring it up, I will certainly give her, ma'am, hang on.
I don't think.
Hang on.
You were supposed to let me know. I owe you pizza. You were supposed to let me know. All right, I'm gonna stop pausing it. But before I do stop pausing it, Leah, thank you so much for the 1 month. That is awesome. I saw your message. You were asking how to drop a milestone. I see you figured it out. Thank you so much. I do appreciate it. You are awesome. Okay. Yeah, Mayor links. Mayor has a wrench. He can drop his own links. Go ahead, Mayor. Yeah. Do your thing, Mayor. I don't care. Okay, we're gonna play this for a little bit.
I don't think we should talk about this much now. You've got it looks like marijuana was the culprit here, right? Ma'am, let me just talk to your lawyer. I don't want you to say it. Well, I don't want you to say anything against your, right, against your interest here. It looks like marijuana was the primary culprit in this, right?
That's what the
So now
last.
you're asking me to say it's okay for her to use marijuana when she got charged with operating with the presence of drugs. I'm not doing it. Now, I don't overrule voters or the legislature, okay? She gets a valid medical marijuana card, you guys can renew your request, but this scares me because you can't go out and drive around with it in your system like that. So that's what I'm doing. NA twice a week, no alcohol, marijuana, or illegal drugs. You cannot leave the state. You cannot violate a law. You must appear in court as directed. You're gonna have to fill out a petition for a court-appointed lawyer going forward here, okay, ma'am? Do you understand that?
No, but I'll figure it out.
Well, this, lawyers are appointed for arraignment. If the rest of the representation is based on indigency, so you have to disclose your income and fill out that form. I'll look at it. I'll be glad to appoint you one if you qualify, okay? Thank you.
I'm sorry, Your Honor, what was the next court date?
October 1 at, what'd you say, 9:30, Lisa?
Yes, 9:30.
Yeah. Okay. Thanks. Aaron Stephen Francia, 25W83927 and B.
Ready, Your Honor.
Oh, she comes back. This is one. I don't know what to say, but we have someone who is, I'm gonna say, addicted to marijuana, and that's hard to say. But her reaction to not being allowed to smoke weed again is troubling, especially after she got a DUI from having too much weed in her system while driving. I don't know what to say about this, but I don't know if you guys saw the very end before I cut away. Like, she was like obviously frustrated. The judge said, you can't smoke weed anymore. No, you can't. You can't. Sorry. Yeah, alcohol is legal. When you get a DUI from actually drinking, you can't drink. And she's like, no, but it's legal. I'm allowed to do. Yeah, it doesn't work that way. Just wait. There's a part 2, which is why this is here, because part 2, she comes up with the attitude. Anyways, Gertrude, thank you so much for the 8 months. Jedi, thanks for explaining. Thank you, Jedi. Yes, if you have any questions about how to do things, just ask Jedi. That works every single time, unless it doesn't work, and then it doesn't work. So I want to say 90% of the time, it works every time. Okay, let's finish this up. Gertrude, thank you so much.
I understand what you told her to do. This Craig.
What didn't you understand?
Did you want 2 NA and
2 AA or NA,
2 NA or 2 AA?
or a combination?
Okay, just 2 total weekly. And then, as far as the marijuana, I wasn't understanding, because I'm
Come on back up.
Come back up here, man.
Alicia Marie Craig, 25W386858B. Slow down. You gotta slow down.
Can I get?
No, just slow down. Tell me your name.
Alicia Craig.
Like Carmen, B73824 on behalf of.
You can go to AA twice a week. You can go to NA twice a week. If it's more of a drug problem, you should probably go to NA. And you can go to any combination. I cannot permit you, I will not permit somebody who comes in here on a drug driving involving marijuana to use marijuana when they don't have a medical marijuana card.
That's not what I'm asking, Your Honor.
What are you asking?
I'm asking, I just would like to speak instead of being yelled at.
Am I yelling at
Not
you?
you, him, when he got upset, he's supposed to be.
No one yelled at you. You're upset that you were just told you can't smoke weed anymore. No one's yelling at you. Nobody. This is, again, one of the few people that I actually believe is addicted to weed. I know someone, I brought the comment up, but yeah, it's like people that are so used to smoking, I get it, but it's not supposed to be an addictive drug. But this is a poster child for why people don't want you speaking about weed when you're addicted to it, because some people are. Some people do get addicted to it, and she's one of them.
Working for me, I'm just trying to understand, even talk to me.
Ma'am,
I'm asking if I come back.
ma'am, let's back it down. Let's back it down.
Yes. I'm asking when I come back on my court hearing, when I drop, there will still be marijuana in my system.
You don't need to worry about that. You're making admissions
That's-
against, hang on. You're making admissions against your interests, which is what I just told you you shouldn't do, and I think your lawyer did, because all I know is they think in the citation that there was marijuana. Now,
Yeah.
it was marijuana's involved. So why in the world would you come up here and start telling me you're going to test positive for marijuana? Don't
Captain Science, that's a great point. That's a great point. Thank you for that.
do it. You're not a lawyer. I know we get at least 7 people in here every day that think they can be lawyers. They can't be. I've seen maybe one do it slightly average in my 31 years on the bench and 41 years as a lawyer. So you just gotta relax. Nobody's asking you to test anything right now. I never said you're gonna test.
No. Because I'm scared because of yesterday.
What happened yesterday?
I spoke 3 times a day that we had said, and I don't want to get in trouble. When I come back to court, I'm scared to get in trouble. You
Slow down.
guys,
Slow down. What happened yesterday? Do you know?
I spoke marijuana 3 times a day, and
Ma'am.
that's all. And I just wanted to.
Ma'am, why are you coming up here and admitting this to me? You got a lawyer.
He said,
Stop. Stop. Ma'am,
Stop. This is the Judge Dad. I love it when Judge Dad comes out. Stop. Just stop. Stop. I love it. Speaking of really cool people, Iron Auditor's in the house. Welcome. Long time no see, my friend. I hope you're doing well. I really do. How is southeastern Ohio? I miss you, man. We need to hang out again. Maybe I'll come down there. Anyways, let's go.
Just let everybody do their job here. Nobody's going to be unfair with you. Why would you come in here and tell me this on the record when you got a marijuana drug charge? A drug driving charge? You don't have any business telling me this. Don't tell me this stuff. I don't want to know about it. You tell your lawyer. And then he can tell me what he wants to say and what he knows is going to hurt you, not say, etc.
And Your Honor, that's why I didn't speak previously, that my client just used medical marijuana.
She can't use medical marijuana because she...
Until today. It's been prescribed her since 2017 for back pain. And
That's great. She's going to have to get a medical marijuana card.
I understand. That's what I.
And then I'm still going to have some issues, but we'll see. I mean, I'm concerned about this. The more I hear, the more concerned I get. And you had 1 4 5 years ago. You're going to have a revoked license, ma'am. If you get convicted of impaired or OWI, you're going to have a revoked license.
Yes, sir.
You're not going to be able to drive from here to that council table right there. You're not going to be able to do anything except have somebody in the driver's seat and you push the car. Stop telling me these things. Talk to your lawyer. I did not say one thing about testing. You put me in a position where I probably have to order testing now.
I was just clarifying, sorry.
Your lawyer knows. He's been in here.
Sorry, and if I may, I just noticed on my schedule, I'm not here October 1st.
Well, whoever is going to be the lawyer here is going to handle the case.
Just want to clarify.
Okay?
Make sure that our lawyer gets his cover.
All right. Thank you.
Thank you, Your Honor.
Thank you.
Mr. Crawford, you guys got to read between the lines. You think there's a big...
All right, that was case one. That was case one with Judge Dad. We have another case in front of Judge Dad. This one, let's just say he's not happy with the plea deal. I don't need to say anything else. Let's go.
25W837-840. I want to know if there's a Jason Haney out there anywhere.
Not on Zoom.
Representative, this is Henry, Matt Sitchin.
That's me, Henry.
He didn't show up. She just had one taken under HIDA. I'm not taking this under HIDA too. This is the same type of thing. So let's call in the prosecutor 249 and we'll go from there. There was a no contact provision in effect. I don't care if he called her up, said, come see me. I don't care what the situation was. You have no business having any contact with any victim here. You know? None. You're violating court orders. I don't have anything on the restitution issue, so I'm going to have to ask Mr. Urich about that too. But here's the deal. I'm going to tell the prosecutor I'm not going to take this under HIDA. Counsel, your appearance again. I'm sorry.
Again, they just proclaimed right now they have in the city, what made it wrong?
She had another case taken under HIDA for domestic violence. She pled guilty a month before this event. She was ordered not to have any contact. She went over there and picked his card.
Yeah, no one in chat got any of those. This is why I'm frustrated with YouTube every once in a while. I had no idea why no one in chat got one of those. People that aren't in chat, it doesn't matter. They're free. I'm giving 10 free subs a month, as I've told you guys before. I donate 5 on the 1st and then 5 on the 15th. I was slow on the 15th apparently. But yeah, give it to people in chat. YouTube, listen to me. Let's make YouTube better. Let's make YouTube great again. Too soon? Might be too soon to say that. Okay. Judge Dad, let's get back to the court.
In violation of the no contact order, I'm just not going to take this under HIDA. I will allow you to withdraw your plea if you'd like. I need somebody to check on restitution on this one. It sounded like when I read the report, there would have been quite a bit of damage. And I recognize again that they made arrangements, the victim and the defendant, to speak, but that does not excuse your obligation to courts. You can't do these things. So that's how I feel about it. You guys figure it out. If you want, I will reschedule it and let everybody grab their bearings, and I'll reschedule it for or you can go talk and resolve it today, whatever you'd like.
All right, yeah. All right. If you're gonna drop that joke, I got another one for you. All right. So if there is a small person who can talk to the dead, commits a crime, and then flees the police, is that considered a small, medium, at large? There you go. I just one-upped your joke. Ha 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 ha. Speaking of, I was gonna say speaking of jokes. This isn't a joke. This is awesome. Lisa, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Thank you so much. Lisa, you are awesome. Very generous of you. And Germerger, penance for Italian ice's addiction. Is this 2 nights in a row? You might have a Italian ice addiction, but thank you so much, Germerger, for the super chat, and Dave Med for the 15 months. Thank you so much. I do appreciate it. You guys are awesome. Very awesome. Okay, let's go. This is a good one, and I keep pausing it. We'll play it for a little bit.
Draw a plea and would like to discuss with the counsel. I'm sure we get it resolved.
All right, I'll just make a note. Told defendant will not take per HIDA. Defense allowed to and did withdraw a plea. So we're back to square one. Now this case has been going on quite a while. So if it's not resolved today, you're probably going to have to set it for a final plea trial and a trial. Plea allowed, withdrawn. Okay, ma'am? Thank you.
All right, so back to court. Part 1 of that. Judge said no. We're not doing this. I'm not accepting this plea deal. Go figure this out and come back. So they went and tried to figure it out, and then they come back. It's bad when you come back and the judge is laughing. It really is. It's not going to work out well for you. Sharky, thank you so much for the 11 months. I appreciate it. And Sparkle Poots for the 20. Thank you. You guys are awesome. Everyone for your membership milestones tonight. A lot of green in the chat. You guys are awesome. Thank you.
Destiny Danye Henry, 25W83780.
Afternoon, Your Honor. Mike Hillcroft, representing Ms. Hinton, who's approaching.
I have not done this in years, but I cannot take this bill for this plea. I'm not going to do it. Your name? I want to make sure I got this straight.
Yes, you are.
Domestic violence charge, HIDA, in front of Judge Hess.
Correct.
Sentenced, no contact provision. Goes and ends up having a reasonable, has some kind of a discussion with the victim, kicks the car door, damages the car. Sounded like a significant amount of damage. I tell you guys I won't take HIDA. Then you come back with 771.1, and now you're going to have me take a plea to a municipal civil infraction. I mean, I'm not blaming you. I'm just telling you, I'm not taking it. I will not take this unless there's a valid reason for it. What's the valid reason? Is she running for Congress? I mean, I'm dead serious about this. What
The whole nature of.
she already pled to destruction of property. And then we go back to 771. And I can't even, I'm not even sure I'm able to. Yeah. What is going on?
Well, the prosecutor and his officer went to great pains and stakes to try to find the best appropriate one that they
Get
could.
the prosecutor and the lieutenant in here, please. My Lord. And the lieutenant. I just feel like sometimes, and I don't want to be the bearer of bad news on this one because I see it all the time. Where's the accountability of anything anymore? She violates a judge's no contact there. Guys, I got to see you both in here, Lieutenant, and you guys, can I have your names, please?
Good afternoon, Your Honor. Please call William Eric. I'm in Hampton City, Woodhaven.
Lieutenant Toller, David.
Guys, what do you think? Does anybody have any clue what I'm thinking? I want to tell you how I'm feeling. I take this young lady's plea. I read the report. I'm aware of the fact that she pleads to HIDA under 7694A. I'm sorry. Yeah, it takes a HIDA plea, I should say, on the domestic. Goes in front of Judge House. He's ordered not to have contact. Has contact with the victim. Sounds like it was a mutual thing. He wasn't innocent in all this, but as you know, I don't order victims not to have contact. I have no authority to do that. They get into a dispute. She kicks his car. I take a plea under HIDA, unbeknownst to me at the time, that she just pled on a domestic in front of Judge Hessen for HIDA. I send it back saying I'm not taking HIDA. You send it back saying take it under 771. And now you guys are sending me a municipal civil infraction?
Your Honor, if I could speak to that, please.
I want to hear it. I got to tell you, I try not to get involved in what you guys do. I bite my tongue up here all the time on both sides. This is ridiculous. So yes, I'd love to hear it.
Your Honor, to begin with, I believe the court was concerned about accountability. The people believe that given the fact that she is on an active probation with Judge Simpson, there may or may not be some form of a violation of probation, not required to be triggered by a conviction, but simply the contact issue. The second feature that developed.
There is no conviction now if I take this plea.
Correct.
There's a conviction for nothing.
And there wouldn't need be at a violation of probation hearing. The contact is a violation of probation in and of itself. As in real time this matter was developing, we tried to reach the victim again. So he has been hailed by the probation department and by us and has been non-responsive. These young people have an ongoing custody issue before the front of the court in the Third Circuit. This young lady, as I understand it, is well employed at a call center, I believe, and obviously the court has all the discretion to disagree with the people, but I believe that given the complexion of things as they develop, specifically with respect to the, what's the word I want? Inactivity or incuriosity of the victim in trying to shepherd this case, I believe that this was a reasonable outcome. Thank you, Judge.
And Your Honor, we obviously respect your concern for the violation of the first order for this.
No, this is Judge McNally, aka Judge Dad. Magistrate Urich is in Michigan, but he's in the 44th district. Is that what Royal Oak area? McNally is Woodhaven. I'm not. I don't live in Michigan, so I'm still getting the lay of the land when it comes to Michigan, but I think that's correct. Oh, it says Woodhaven. Oh, it actually says Woodhaven on the screen. So yeah, hey, look, I guess right.
Counsel stated, my thought process was similar. If Judge Hessen has an issue with it, she can be held accountable for that violation before that court not be penalized here in a separate subsequent case.
Guys. I must be missing some.
I will tell you that Mr. Urich, I have seen him in as a prosecutor in other courts, and I believe he's been in this court before. So there is a chance that you are correct on that, but that's I'm looking. It doesn't look like it might. You know what? It might be. You might be right. It might be Mr. Urich as the prosecutor. I don't know. I don't know. But that is absolutely possible.
So because I say I can't take this under HIDA, and I'm not going to because it was a domestic dispute, and she just pled guilty to and been sentenced on a domestic dispute a month earlier. And then you guys sent in the 771, and now you want to tell me Judge Hessen can revoke. Judge Hessen can take steps on her case. Number one, I don't care what people do. I made that abundantly clear. I don't think we treat people better. Call center, great. Lawyers, doctors, dentists, priests. I don't think we treat anybody differently based on who they are, what they do, who they know, or how much money they make. And I've said that for 30 years, and I believe it. So let's throw out the employment thing. Let's not talk about her employment. Let's talk about something called justice. Let's talk about something called justice. Let's talk about something that has to do with holding people accountable. Giving them breaks when they're deserved. And everybody deserves second chances. But not in this scenario. I find this to be, first of all, let's just call it the way it is. Judges are not really legally authorized to tell people that they're not going to do something that the prosecutors are off. This used to drive me crazy when I was a young judge. Still bothers me a lot. Because there's no justice being served here. I just want you to know that's my feeling. And when I'm done doing this, I'm going to take this plea. I'm going to take your plea, man. You're going to walk out of here with something that is 99.8% better than what they offered you 2-3 weeks ago when you pled to malicious destruction of property. And the only one that called it was me. Because it isn't right. It's not right. I don't care what anybody. You could line up 150 prosecutors, they could all agree with him. 8,000 defense lawyers, line them up, they could all agree with him. I'm still going to be the one to say this is wrong. It's just wrong. It's just wrong. The idea that Judge Hessen can or cannot do something or should or shouldn't do something is part of this agreement I find to be hogwash. But the thing about me is I'm not going to overstep my bounds. At least I do my level best every day I come in here to not overstep my bounds. I think this is ridiculous. I'm just telling you. You have a deep problem going on right now. And that deep problem consists of, for whatever reason, a lack of respect for the judicial system. And it's cases like this that make me say, gosh, I can understand somebody thinking this is nonsense. I just can't. Now you're going to walk out of here in great shape, and the only thing is you had to listen to an old guy talk to you and call your case 4 times today. I do. I just want to go on record and say, I don't agree with this. I don't think it's right. And if somebody gets hurt in this, the blood's going to be on somebody else's hands. That being said, you're recommending a fine of $150 under 94-2. I think I have absolutely pretty much no authority, although I just don't believe in the logical nature of your argument, Mr. Urick, but nonetheless, I'm going to take that plea, municipal civil infraction 94-2. What is it called again?
It's misuse of streets and sidewalks, Judge.
Misuse of streets and sidewalks. Now forget one.
Misuse of streets and sidewalks. She kicked a car and did damage to a car, and she just got a deal for misuse of streets and sidewalks. Come on. We can all understand why Judge is upset. What about the victim? Where's he at? Or she? I don't know why I just assumed he. I'm assuming genders over here, apparently. Yeah, where's the victim? Like, what if they want restitution? I don't know. I'm not going to pretend like I understand what is going on, but I feel judged right now. I do. Doesn't make sense. Doesn't make sense. Misuse of streets and sidewalks. That's a good one. That's a good one. It reminds me of the guys, Fresh Prince of Bel-Air, when Uncle Phil was teaching Will how to drive, and he was really upset. And his line was, "I don't care how pretty she is, you can't drive on the sidewalk." You know what? That was misuse of streets and sidewalks. That would be appropriate.
Forgive me, I gotta laugh. Did she spit on the sidewalk? I don't want to talk about it. I mean, I feel like I gotta go take a shower after just even presiding over this case and take a plea to the charge of misuse of streets and sidewalks. How do you plead? Responsible? So she kicked the hell out of the guy's car. He's not here. He didn't show up for restitution. Original charge is dismissed. Motion to the prosecutor. Agreement of the defense. Ma'am, go down the hall and pay your $150. And consider yourself, you should probably go buy a lottery ticket or 49 of them right now. Have a nice day.
Yeah, you got to the end of today?
4:00.
Thank you, Your Honor.
Thank you. Anthony Stefani. Are you Mr. Stefani?
No, he's not the number on there.
Anthony Joseph Stefani.
All right, we're moving on. No, I did not say the victim was a cop. I didn't say that. I don't know who the victim is. I think I said, where's the victim in this? Is there restitution? I don't think I said anything about being a cop. I hope I didn't. I know nothing about the case. I really hope I didn't say that. Jess, for 18 months, a year and a half. Thank you so much, Jess. I do appreciate it. You are awesome. Thank you for the milestones. You guys are killing it with the milestones tonight. Absolutely killing it. Thank you so much. All right, we're moving on. From Judge Dad to Judge Simpson. He had a couple good ones today. Let's go. We got a few Mr. Allen moments. Don't worry, ladies. Mr. Allen is present today.
Court does call the case of the People versus John.
I'm here.
Yeah, hold on a second, miss. Let me do this one and then I'll come right back to you. Okay, Miss Fox?
Okay, I'm sorry.
Ron Brown, appearing on behalf of Mr. Funk. Do you have the plea form, Your Honor?
I do.
Good day.
Hello, what's your name?
John Michael Funch.
All right, Mr. Funch. The plea form that I have indicates that the defendant will be pleading to an added count to a retail fraud.
Oh, I'm absolutely one of them. Yeah, I'm one of them. Let's just say it might be one of my goals when I go see Judge Simpson for Mr. Allen to stand behind me. I just want that picture. I will make that my profile picture and I will never change it. Jude Curio, good to see you. I haven't seen you in a while. Jude Curio as Thunder Snow. 17 months. Good to see you, my friend. Hopefully you're doing well. Thank you so much for the milestone.
In the third degree, the 93-day offense on a successful plea, count one would be dismissed. That's the entire understanding of the.
That's correct, Your Honor.
May I have him sworn? Is that correct, Ms. Counsel?
Yes, sir. I'm just pulling up the plea form, but I'm sure that's right.
It's okay. Let's have him sworn.
I believe you.
Raise your right hand. Do you solemnly swear the following testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I sure do.
State your name.
John Michael Bunch.
All right, sir, it is this court's understanding you're going to be pleading guilty to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus.
How dare I keep myself on the side? I need to make it bigger so you guys can see Mr. Allen a lot clearer.
Court cost of fine could be increased 3 times the value of the property taken. If that's greater than $500, that would be your maximum fine. You understand that?
Yes, I do.
All right. And understanding all of that, you still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation?
No,
Are you on parole?
not at all.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, not
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
I am, Your Honor. Yes.
Yes.
Yes,
And because you believe that you're guilty of this offense?
I am. Yes.
March 5th, 2025, at the location of 3300 Carpenter Road in Pittsfield Township, Washington County, State of Michigan. What did you do at the Home Depot that makes you think that you're guilty?
I had.
Oh, he has one. It's the jury cam. Mr. Allen sits right in front of it. That's his spot. Every once in a while, it just goes to him, and he's just playing on his phone. It's hilarious. But he absolutely has a Mr. Allen cam.
I had a tire to return, and I kind of just returned it myself, and there was a $20 difference, the price, and I just walked out with the tire.
You had a tire?
A tire for my wheelbarrow.
Oh, okay.
It was dumb.
And so
He purchased a tire at $39.
Right.
It didn't fit, so he brought it back into the store. And rather than waiting and doing the exchange with the customer service, he selected a $59 tire.
Is that all correct, sir?
It is, yes.
So, and then when you selected the new tire, you did that and you walked out without paying the
I
difference?
did, yes.
And you knew that's what you were doing at the time?
Yes, absolutely.
All right. You didn't have anybody's permission at Home Depot to do that, did you?
No, not at all.
And the item that you took out that was priced at the $59, that was an item that they had offered for sale?
They did, yes.
All right. Counsel, have I complied with the court rule? Well, sir, I do have to advise you that if between the time of the acceptance of this plea and your time of sentencing, that if you commit misconduct as defined by the Michigan court rules.
Don't even think about it, Jedi. Your wheelbarrow takes like off-road tires that probably cost like $300 a piece. You can't buy those at Home Depot. You got to order them special. Don't even think about it. You can't do that.
You would not be entitled to withdraw your plea. You understand that, sir?
Yes, won't happen again. Yes, I do.
And also, sir, any recommendation or evaluation by the court would no longer be entitled.
Yes.
The court would no longer be bound by. You understand that?
Yes, I do.
All right. Second, okay. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
October 22nd at 12 noon.
October 22nd 2025, 12 noon. Sir, looks like you have some other issues here.
No?
Well, I'm not.
Oh, sure.
Mr. Allen.
You don't have no warrants.
No, I don't.
Mr. Brown heard that. Mr. Allen, this isn't good. I've got a lot to say about this, but I'm gonna let the rest of this hearing play out. This is you know what? Dan, I'm probably gonna need your input on this. So pay attention to what's about to happen. I'm not happy about it.
Yeah.
Right, I've got 2 warrants, and I've got a warrant which this is an old case because it has a 97 case number on it, and it was transferred from our original case management system into the new one. I'm not sure why it appears the way that it does, but it's a civil case, but for whatever odd reason has a 5,000 10% bond on the case. And they issued the bench warrant. It was a Samuel Hall Jr. versus John Prince. I don't know why that, when I'm looking at the case, there may have been, oh, I know why. All right. There was a subpoena, and I'm having to piece it together, but there was a subpoena that was issued. You didn't appear to court. Ultimately, at least my procedure was there was a show cause and then a bench warrant because you didn't appear.
Does it show he was served though, the subpoena?
I'm not.
I didn't know that.
There was a point at which there was no service. I do see that on here, but then they filed a new subpoena. Discovery was filed, and at a later date, then the bench warrant was issued. So I have to assume that the bench warrant was issued. That was, although it's a 97 case, because I took over that docket, I'm listed actually as the judge of record in that case. But I would not be the one that would be handling it now. What I'm going to do in that case, because it's so old, on that one, I'm going to cancel the bench warrant. All right. And then I'll just indicate that they need to reset before Judge Barr, who's handling our civil docket. You have another civil case that's from 2020. And the plaintiff, and it's a civil matter, is a Suzanne Riesel. I don't know if you know that person versus you. In that case, again, it appears the same thing, except in 2023, a debtor's exam was scheduled before Judge Barr. And on April 18th of 2023, you failed to appear for that debtor's exam. The judge issued a warrant.
Was notice returned or?
I have no idea. I'm just looking at the file or at the printout. I would suspect that if notice were returned and Judge Barr knew about that, he would not have issued a warrant. But a bench warrant was issued on that. Um, a bench warrant for whatever odd reason, even though it was in April, was then issued October 10th of 2023, and it's gone through this year in February. The warrant was valid.
We have case numbers because we don't have access.
I canceled the one,
Okay.
one case number. The one that there's a valid, let me just give it. One case number is 97-2C3143. That's the one that I canceled the warrant on. The other one is 2004 C0243. Both of them, it appears, come from small claims matters.
Your Honor, is there an address in the 243? I'm trying to make sure you got notice of all this.
In the 243, there's the address of Parker Road. And the warrant and everything came through, whether or not that was, no, I'm sorry, it's not Parker Road. It's Outer Drive. It's the same address that I have on this case.
So I'm asking the court to not take him into custody, but
it's a valid warrant. You're gonna address that before Judge Barr. That's his warrant that was issued on the civil case. It's a cash bond only warrant from his failure to appear for a debtor's exam.
But Your Honor, I'll be brief. As the court knows, we don't have access to JIS. Usually we'll run our clients' names through JIS and have the benefit of at least alerting our clients to warrants. Without access to JIS, and I interviewed him in the court, I interviewed him in the interview room, he wasn't aware of any warrants. That's why I was asking about the addresses and whether he had properly been served the subpoenas or served with notice of those debtor hearings. And so because I don't have JIS, I can't help him.
I will straighten it out.
Well, I understand. And Mr. Brown, I appreciate what you're saying. I think it's what has transpired is just crazy regarding JAS. I don't agree with any of it at all. I think certainly to those that have asked, I've expressed that. This is the one danger that happens. People get locked up because you guys who do a fantastic job don't have the benefit of being able to get open access to the information that's contained in the case management file. It's an abomination. I do consider it. If you raise the issue, it may be a violation. I'd have to look at it as an individual's due process and constitutional rights, because I have to do what I have to do here. But the court itself, quite frankly, is impeding your ability to do that. Something's wrong. There's going to have to be a ruling on it if it's raised. So you are more than free to raise that before me, since I'm the one sending, or raise it before Judge Barr because this is his case. But at this time, I do have a valid warrant. I'm going to take him into custody, sir, so that you know the bond amount that I have here is $2,650 cash.
How much? 2,000?
$2,650.
You got that on?
No.
Alex, this was a big deal. I don't know if you guys remember when I was going to drive up to see Mr. Magoo and I was talking about canceling because there was a big, tech issue with the court. Whatever JIS is, I'm not exactly sure what it is. It's some kind of system where they, the attorneys can look up criminal records, I'm assuming. But that's the day where JIS just stripped the public defender's ability to look at it. I don't know why. I don't know what's going on, but they weren't able to see that this guy had a warrant. And my question is, Judicial Information System. Okay, thank you, Serena. My question is, for every time I hear a judge say this, It's not true. When they say we don't throw people in prison for debts, there's no debtor's prison in the United States. This guy has a warrant out because he missed a civil case for a debtor's exam, and he's going to jail for it. It's a civil case. Like I don't know what the case is, but this seems extreme. It really does. And I'm guessing the 2,600 whatever it was is how much he owes, so that's his bond amount. No, I understand he didn't show up, but it wasn't just a default. When you don't show up for a civil case, they issue a default, and then whoever is claiming against you goes through collections. That's how it works. Yes, I understand he didn't show up. Yeah, the FTA, but why wasn't it a default? So what's the difference between a debtor's exam and a just a normal small claims case? What's the difference? Maybe that's where I'm confused. So a debtor's exam is different than a small claims case where someone's trying to collect money against them? Okay, maybe that's my issue. I don't understand the difference between the two. All right, let's finish this one up. We're almost done with this one.
That sounds like on the civil case, that may have been the judgment amount, and then when you didn't appear for the debtor's exam, that became the bench warrant.
What can I say? How do we get a hold of them?
Hold of who?
The people I owe the money to.
Well, hold on.
Well,
You got to go with the court officer. And if you got a credit card or somebody you can holler at, you can call for the 265. Maybe you can post it.
Not too.
Yeah, Gertrude, I agree with that. When people are ordered to, do drug testing like 2 or 3 times a week, and it's $12 every time they test, and they're unemployed, they just get out of jail, and they're supposed to pay $50 a week to drug test, as well as living, and they're trying to get a job and they get thrown in jail because they can't afford a test. I agree with that. That system sucks, Gertrude.
65, 2,000.
Oh, 2,065. No 10% privilege?
It's a cash bond that normally would come up for a civil case.
So you got to go with the court officer. Make some calls.
Go with the court officer. Mr. Brown, if for whatever reason he's not released or there's some difficulty and you can't get before Judge Barr to adjust or do something, I will entertain whatever motion you have, because I realize this would not have happened but for what has transpired over the past few weeks.
Thank you, Your Honor.
You're welcome. You only had to post for one bond. I canceled, so that you're clear, I canceled and just wiped out the 97 one. That may come back to be, but it's from 1997, so it's older than I am. I'm not gonna do that.
Well, Jay,
you don't have to laugh. You really did. You could have just let that ride.
I'm sorry.
Will JIS reflect the cancellation so that the other court knows?
Yes, because we brought that over from the old system. It's in the JIS system, which you can't get to, but it's in there, and I wrote on there that I'm canceling that one out.
And the sheriff's will. It'll be canceled.
They will not, because they lost their access to JIS when the court did what it did too. So a whole huge mess has been created. I don't know what they're going to do when they see that I'm putting him in on a warrant, because to the extent they're able to look up a criminal case, I don't know what they're going to see the civil. I have no idea.
Can I ask one thing?
Yes, you can ask one more question that I can tell you I do not know, but go ahead.
May I have a copy of the cancellation that you put in the file so I can give it to him?
I just wrote it.
Yeah, but
I can write it on another piece
so if
of paper.
he walks out, gets pulled over.
Okay, so here's what the problem is. Yes, I get it, Mr. Brown. The problem is that I wrote cancellation on my JIS printout. Supposedly, you guys aren't supposed to have that. I don't know why. It seems stupid. That's a legal term.
And so I can't give you that.
You give to him?
No, I can't. I don't think. I have to think it through. To Brown. I don't know that you guys can even do this. This is also what's weird because you guys represent people on criminal matters. If you were to indicate to me that you're the attorney of record or get him to sign something that they would like that information turned over to you, that's fine. You're trying to get some verification that I canceled that warrant.
Yes,
Because you can't get to the place that it would be. So here's what I will do. Ms. Weidling,
Yes, Your Honor.
could you type up a document for my signature to present to the public defender's office that I can't, on the 97 case, that I canceled it? I will sign that, and that way you have it in writing from me.
Yes.
Thank you. That took much longer than it needed to. Court calls the case, not because of you, Mr. Brown, it wasn't. Just stupid stuff. Trayvon G.
I've spelled this with people.
All right. Yeah, that one frustrated me, which is why I played it. You guys heard the frustration in my voice when I was commenting. Cat in Virginia, thank you so much for the super chat. Can a lawyer in chat explain how this would have been different if the defense attorney had access to GIS? They would have had prior notice to that there was a warrant, and they may have been able to contact Judge Barr and get the warrant lifted before this hearing. They could have probably done all that before the hearing. So that's my guess. It's such an old case, and it's a debtor's. I don't know. The whole throwing someone in jail for a debtor's exam is it's baffling to me. So I don't know. Oh, Uncle Dan responded. I'm not sure about that. I think that Mr. Brown had access. I think that if Mr. Brown had access, he could have tried to get the warrants from the civil matter quash. Yeah. Okay. So that's kind of what I just said. Hey, I feel better at myself. I feel better at myself. No, words are hard. All right, we got one clip left. It's a super short one. We're going to Judge Shackelford's court. I don't remember why I put this on here. I remember I wanted to vent about something, but I don't remember what it was. So I put the Judge Simpson clip because it frustrated me, and then I put this here because I wanted to vent about something, but I don't remember what it was. Words are hard. Words is hard. Absolutely. All right. Hopefully, by playing this, I'll remember what I wanted to vent about.
Have a good day.
All right, thank you. You're all.
What I will say is there's only about this clip's only about 3 minutes in the last clip of the night. So, yeah. Night is winding down.
Mr. Mays, have you met with your client already or with the prosecutor?
I have met with the prosecutor, Your Honor. I don't think that my client is here.
All right, well, we'll sit tight for a second.
No, it's fine. I've got authority to resolve it.
All right, give me just a second. I don't have the file. I just wanted to know if you were ready, if I did have the file. Yes. So give me just a moment.
Oh, I remember what I wanted to say. I remember. This is Mustache Maze.
All right, and Mr. Cassidy, just sit tight. I'm waiting for everything on your case. This is 25TA 18496 ABCD and E, the City of Taylor versus Trust Petroleum.
Good afternoon, Your Honor. William Mays on behalf of Trust Petroleum. I have authority to enter a plea agreement on this case. The prosecutors agreed to dismiss all but one count of the various charges brought against Trust Petroleum. The one remaining count, overweight, they're being extra generous on this one because it was actually the axles were up on the vehicle when it was weighed. So the prosecutors agreed to a $2,000 fine, which is a substantial departure from the normal fee schedule, with 30 days to pay.
All right, and Mr. Mays, I'm sure you said this. It's been a long day. Do you have authority to enter into that on behalf of your client?
Yeah, he's been everywhere, not just Oakley's court, but yeah, the case I covered, the long bench trial where Judge Oakley pretty much kicked everyone out at the end. Yeah, this is Mustache Maze. The thing I wanted to vent about is how Judge Shackelford treats attorneys different that are friendly with Judge Slavin. But I'm not going to do that tonight. It's been a long day. I was gonna, just kind of vent a little bit about Judge Shackelford, but not gonna do it tonight. That's not happening on the record. Not tonight. But you can tell she's over him. Just anybody that's friendly with Judge Slavin, she does not give the time of day. Like, this is a super easy case, just get over with. And she's just like, whatever, you're here, okay, let's get it over with. Yeah, just I'm done with it. I'm done with the game she's playing. Okay. Yeah, we're gonna play the rest of this clip now.
I do.
All right, and it's alleged to have occurred on July 18th of 2025 at the city of Taylor, commercial overweight vehicle with a stipulated fine of $2,000. Responsible or not responsible?
Responsible.
All right, I'll accept that plea. It's a $2,000 fine with 30 days to pay. And the B, C, D, and E file are dismissed pursuant to that agreement.
Thank you, Judge. Have a great day.
You too. Thank you.
Yeah, that was it. I put that in there just to I wanted to vent. But it's not the night to do that. It's the end of the stream. I'm just gonna call it a night. There will be a night here shortly where you're gonna hear me kind of go off, but it's not gonna be the night. You guys are awesome. Anyways, that's the end of the night. It's the end of the night. Does she not like Judge Slavin, or she actually hooked? She does not like Judge Slavin. She's not a fan of Judge Slavin. That's why he's not on the bench right now. That's all I'm gonna say about that. We're gonna talk about that at a different time. Anyways, you guys are awesome. Thank you so much for hanging out with me tonight. You guys blew it up with membership milestones tonight. You guys are awesome. Thank you. How many times am I gonna say you guys are awesome? It's time for me to call it a night. I've got to set up to raid KFAR. It's Booze and Body Cam tonight. So yeah, go hang out with KFAR. Make sure you go tell him I sent you and say hello to everybody on my behalf, because I'm gonna go crash. I'm tired. Have a great night. You guys are awesome. Thank you so much for the membership milestone, super chats, gifted memberships, mods. Thank you so much for your hard work. You guys are also awesome. Still, I need to learn a new word, but I'm gonna keep saying awesome. Anyways, go tell KFAR I said hi. Katie Zed's there too. Go tell her I said hi too. That's it. That's all I got. Till next time, bye.